Mrs. Davis, who was visiting Brisbane City on a summer's day in 1951, parked her car at Goff's Auto parking station in the city centre. She paid her money and received in return a ticket called a parking cheque. The idea was that she would leave the keys in the car so that it could be moved within the parking station and then return with her parking cheque when she was ready to retrieve her car. Unfortunately for Mrs. Davis, the car was parked in a spot where it could simply be driven out of the car park, across the curb and onto the street. An enterprising, well-dressed thief got into the car, intending to just drive it away. Remember, it was unlocked, and the keys were still in it. A staff member, Miss Smith, saw him do it, but he gestured towards the office, and he seemed to have something that looked like a parking cheque. She assumed he was picking the car up for Mrs. Davis and that he'd already checked in with the office. And so he drove away. The car was later recovered badly damaged in Adelaide, and the thief was convicted and imprisoned. That didn't help Mrs. Davis. She sued the car yard for negligence. It was pretty clear that they had been negligent. However, the parking cheque included the following: the motor vehicle mentioned on the other side hereof is garaged at the owner's risk, and Goff's Auto parking station will not be responsible for loss or damage of any description. The question for the High Court was whether the exclusion clause was valid to protect the car park from their own negligence. In making its decision, the High Court did not make new law, but rather the court took the opportunity to confirm the position from earlier authorities. The court said, "It has never been doubted that a bailee may exempt himself by express contract from the consequences of negligence on the part of himself or his servants. But it has repeatedly been said that an exempting clause must be construed strictly, and that clear words are necessary to exclude liability for negligence." In this case, the words in the parking cheque were considered sufficiently clear. Even though they were expressed in general terms, they excluded loss or damage due to negligence. Sadly, Mrs. Davis lost both her car and her case.